Hello, hello, hello. This is attorney Mike Grevin coming to you from Chicago, as usual. A little bit early today because I wanted to squeeze in an intro. So let's get this thing started. Thank you, Night and Neat. All right. So I think we're warmed up and ready to roll here. I'm going to try to put the stream on here. Let's do that. I need to get it started though.
Those are the two prongs of defense so far. Or has activated a noise-making device. Okay.
Well, this is meta.
That's interesting. I appreciate that, Brittany. These guys are on top of it. Like, okay, I get it. Here's why we're muted right now. But they anticipated that.
I like this comment. I really do.
A creative perspective, I'm like, really? You had a message ready for that scenario? I am duly impressed. Well done, our Nevada judges, as usual.
Oh, it's on. It's happening. Can you guys hear me?
So Mr. Dickerson owns you?
It doesn't say, hey, I'm going to file a complaint against you regardless, but I'd love an apology.
Did he really mean to extort anything of value?
In my investigation, going over years and in fact decades.
Oh no, testify as an expert witness.
An expert in what?
I'm an expert in my own religious beliefs after studying comparative religious beliefs. And my religious beliefs are what motivated the conduct that the district attorney finds criminal, and which is no means is criminal.
Respond yes or no to whether the matter has been resolved.
It sounds like Mr. Blandino is not going to sign the guilty plea agreement that he agreed to sign based upon him continuing to want to challenge this court's disqualification.
I believe he also has a motion in federal district court to address the mask mandate, is what he mentioned in this one.
Okay. All right.
Yes, Sean.
Has the jury reached a verdict?
Yes, Sean.
Will you please hand the verdict form to Officer Hawk? Okay, the clerk will now read the verdict out loud. If the defendant and his attorney will please stand for the reading of the verdict.
District Court, Clark County, Nevada. State of Nevada, plaintiff versus Kim Dennis Blandino, defendant. Case number C341767, Department number 12. Verdict. We, the jury, in the above entitled case, find the defendant, Kim Dennis Blandino, as follows. Count 1, extortion. Guilty of extortion. Count 2, impersonation of an officer. Guilty of impersonation of an officer. Dated this 9th day of March 2022. Signed by 4 persons. Ladies and gentlemen of the jury, is this your just read? So say you one, so say you all. Yes.
Yeah, you guys got 2 for Spanish. We'll see in Spanish. You and anybody else in here? You? Yeah.
Thank you, Brandon. Thank you, Gia. Oh, those are my favorite causes right there.
is how do we make our courts better?
Thank you.
And we have to deal with the backlog. And one of the things that I've committed to doing is to issuing any decisions that come before me within 2 weeks of the hearing, because I don't want anybody waiting on me to do my job so that their case can move along, they can get some closure, they can put this part of their life behind them. It's something I do right now as an attorney. It's something that I do as a judge. And so when I serve as a fill-in, so there's no reason I can't continue that into the future.
I'm Henry Sotelo. I came to Reno to attend UNR and fell in love with Northern Nevada. I practiced criminal law for over 25 years as a prosecutor and now as a specialty court attorney. Reno Municipal Court has embraced the therapeutic court model in order to address criminal behavior linked to substance abuse. These specialty courts save money, rehabilitate offenders, and reduce criminal behavior. No one in Reno Municipal Court has more experience in specialty court representation than I do. If you find yourself in trouble with the court, I can help.
I'm your host, Scott Coffey, and we're here on Our Nevada Judges to talk about self-representation and the right to stand by counsel. It's a subject that's near and dear to my heart, and I think it's appropriate to be discussing it on the eve of the 60th anniversary of probably the most successful case of self-representation that I'm aware of, Gideon versus Wainwright, that established the right to appointed counsel in cases where liberty is at stake. Abraham Lincoln, of course, famously said that anybody that represents himself has a fool for a client. Hopefully by the time we're done with our panel, we will be able to answer whether that's still true.
All right, I'm just going to mellow that out. I have to come over here so you can see my glorious ascot.
In the right to
my ascot with the
right to stand by counsel. To my right, I have a distinguished panel.
I'm going to start the new ascot with a fleece trend.
Welcome all of them to the show today. We have Teresa Main.
It's very fashion forward.
And my dear friend Fakisha Miller, and I'm going
to let you got a pup named Captain Jack. That's pretty sweet all by itself.
Teresa Mains, and I have been practicing in Las Vegas for close to 6-7 years.
Amber Vegas, thank you.
Accountant. Part of my experience with people that want to
take Bateman for a beer. I will when I although I don't think he drinks.
Appointed by the NJA.
But I would definitely go out for one with him if we're ever in the same town, which will happen. It will happen eventually.
I work with fraud on defending and
the
prosecution side on civil level.
Yes, my name is Ben Bateman.
When this gets going, somebody yell at me.
And currently I'm a solo practitioner, and I've been about 8 years now. And I am on the panel, the Office of Appointed Counsel.
Thank you.
Panel.
Thank you.
Now, but I have some experience being appointed to stand by counsel.
And by hot, you means
I've
not
been
hot.
practicing mainly criminal since about 2007.
Fakisha, you've done almost everything.
I have, but just really briefly.
Thank you, Brenico.
I'm Fakisha Miller. I've been practicing law for 20 years, licensed in the state of Tennessee as well as Nevada.
Yeah, Fred from Scooby-Doo had it going on.
2014 at the Public Defender's Office for 6 years. I've done criminal practice most of my life.
I don't think there are any appeals pending yet, but I could be wrong.
Mainly civil. The last year during the pandemic, I was the chief negotiator for Clark County School District and got the schools back open and running.
Thank you, Adamar.
And then now I'm in private practice as senior trial attorney at Nevada Defense Group.
Very good. And by way of background, I'm with the Clark County Public Defender's Office. I've been there since 1995. Hard to believe. I have the gray hair to show it. I do primarily capital work, and have done capital work for the last 20
It really
years.
is good.
But even with that, we get
I've got Kick to thank for it. I took the clip
let's
from
start
him.
by talking about self-representation.
But since I've been using it for 3 months now, I really should periodically credit him again.
How's it work?
Well, someone wants to represent themselves. I think generally when I see it, there's always that sentiment that no one can represent me. Or
Well, there you go.
As well as
apparently they are, and they haven't gone anywhere.
Either because
was that Ben?
They know all the facts, they went through the facts and the experience of the case, or they've studied so much that they know. There's also another sentiment that they know more than the attorney does. It seems to be a common theme in people representing themselves.
No more than the attorney does about the case, but usually not about the law.
depends on the on the individual.
Oh, it is fun. Thank you,
usually,
Bomos.
They want an attorney, usually a standby counsel, maybe someone to help them procedurally. But yeah, usually the sentiment is they know more, and so they're best positioned to defend themselves.
How do are the courts receptive to this idea of standby counsel?
Well,
One never
if you're
knows.
talking about
But thank you,
historically, yes,
Captain
that's where the
Colombo.
whole framework comes from in our constitutional amendment and why you have the right to represent yourself. So historically, when people use the term star chamber, that was in British rule, where literally the king would just give you a lawyer to facilitate your
All right,
prosecution,
I'll get back over there
even
to
though
this.
they were
Let's
supposed
see
to be
what's
for your
going on.
defense. And I think it's really amazing that, 300, 400 years later, we are now seeing our public feel the same way, that they cannot be defended by the system or court-appointed attorneys, that they can do better all by themselves, or maybe with the help of somebody sitting at their elbow.
And I suppose there's a natural tendency to be concerned about somebody, you say appointed counsel, somebody you don't pay for, right? If you're not paying the bill, you worry that they're working for the system. Maybe.
Am I caught up?
Have you encountered that as a
Certainly.
appointed counsel?
Oh yeah, absolutely. People think, well, if he's working for free, he
thank you,
doesn't
Don
care. He
Rayhouse.
just wants to deal it and get it done because he's not. And a lot of times, it's something I, tell them. Going to trial is in my interest because I get paid. I get paid for going to trial. I get paid hourly, and a lot of times they're surprised. They don't know that, and so I'm like, so. Me telling you to take a deal that trial is not in your best interest is really for you, because for me it would be better. I would make much more money on this case if we went to trial. But my job and my ethical duty is to represent your interests, not mine.
Is a public defender in the same spot that they're salaried, right?
Yes. So I'm different than a public defender in the sense that I'm using these cases. Yeah, I'm paid hourly.
Run it at 1.5.
Well, and it is hourly. Like with federal, there's the NJA, and it's it's a
Iceland in the
lower
house.
amount.
Now that
but
is
it's
awesome.
Still hourly. I mean, my experience with
We've got characters I literally can't
been
pronounce.
standby counsel I covered for
'Cause I don't
a
know what
very,
they are,
very
but it's awesome you're here.
prestigious,
Thank
in my
you.
opinion, very well reputable attorney David Fisher. After a motion to proceed pro se is filed, and this person wanted to defend themselves.
They should really
and it
ask him
wasn't-
about this. That's what I'm saying. Love it. Thank you, Susie Q. 42.
Hearing to determine whether he's of sound mind. Does he know?
I don't know.
that
I don't
he
know
goes
if
to
Alex
trial,
is live.
The maximum
I
penalty
chatted with him. He just
will be
confirmed to me
300 months.
that it was going
When
on
we
at
talk
the
about
appointed time.
Canvas, what we're
I
talking
think
about is
he-
a
I think he
series
might
of
be live in
questions
the
that the
courtroom.
judge would
Otherwise, they
be
can't play
asking
this
Beretta
background
canvas,
stuff and know
that's
when to
right.
switch
Beretta
over.
canvas.
Beretta canvas.
That's the case.
that establishes the right to
Well, I
represent
guess he could do that
yourself
remotely.
in any case,
Well,
essentially, right? Including capital cases.
Our Constitution says you have the right to represent
I-
yourself. Beretta
That is an
is
advanced
the
dance. I
case
don't know if I
where,
can pull that off.
though the court did not want the person to represent themselves, that sort of entrenched it under our Supreme Court. But yes, actually, our
Thank you,
Constitution.
Go West.
Why would the court not want somebody to represent themselves?
For multiple reasons. Multiple reasons.
I wish I knew how to do it. I want to know if you guys think he's going to get jail time or not, but I don't know how. Let me see here.
Generally,
Let me
if
see.
you have a competent lawyer, the trial is going to proceed more efficiently, number one.
Let me
Number
see.
two, you don't have to slow down and explain things to another attorney like you would a pro se litigant, because as the other
Let
panelists
me
mentioned,
see what
the
we
record is everything. So if you have, and I mean, they're pro se litigants, I mean, they're coming out more and more. I've seen a real big movement toward this in the last 10 years. And so I have seen people that you would never expect that would want to represent themselves. I believe there's one that's in trial, just wrapped up here in Clark County. I believe the pro se litigant was mute and could not speak. And so all of the questions that they had to ask.
In jury selection right now, it's taken 7 days so far.
Yeah. So
It
that
would take usually
2, well, in a murder case, 3.
Was he muted, or he just that's a physical? He cannot speak.
He cannot speak, is my understanding.
Okay.
So yeah. So, but I mean, you have the right to do that, but for court efficiency, if you had a lawyer to speak for you, and excuse the pun, but that would be a different instance. The other thing is that it protects the procedural rules. Lawyers understand the process. You have a less likelihood of reversal. And I think there is the idea of a shield that when you have especially heinous charges, that in order to have a meaningful defense, you need to have someone else speak for you. That's why, if you don't testify, it can't be held against you. You had someone to speak for you, even though it's not evidence, but to ask the questions you could have asked.
We give juries instructions that say you're not supposed to prejudge things. You're not supposed to make a decision until the facts have been presented to you, till the witnesses are done. Do you think they actually follow through with that, though, with a pro se litigant? For example, in your situation where you have somebody accused of a sexual offense.
Heinous was like the key word in that one, and I think that's like an extreme case, but it gives every single example. There was one motion in limine that he wrote while he was pro se. So fast forward when he's in trial, and there was a lot of stuff that it was excluded from, like past offenses and everything. So if he's in trial, he can't discern.
Please tell me we're not missing
what
this.
is excluded, what is not, and whose fault is that? That's like,
And Bennett mentioned credibility. With a client, there's also credibility in front of a jury, and I have to imagine it is difficult for somebody representing themselves to stand up and say, "Trust me, I didn't do anything."
Right, and also just your question.
I don't know what's going on here.
For an attorney representative, because I think if someone is pro se, I think there's the temptation. Maybe they don't care. They don't have a bar license to worry about.
Right.
It's their life on the line there, whatever, their freedom, their future. And so there's that kind of, I think, the feeling maybe like a wild card, like you don't know what's going to happen. If things are going poorly, is this guy going to shout out? Is he going to do something crazy? I don't know.
All right, come on.
But I mean, I
is
think
this the
there's
8th Judicial Circuit? I know it's not. I know it's not the 36th.
One, not being bound by bar exam or losing your profession, your livelihood. No attorney.
Let's get on with this then.
I mean, yeah, you can zealously.
The call started and they just haven't called him yet, but I would think that this is especially set. I would think it's the first case called.
For that, I'm not going to put my license in jeopardy.
When I've watched
all right, this thing's too hot.
I've seen clients who are adamant about representing themselves.
In terms of temperature, not in terms of style.
It's like being on a high dive and having to jump off, and they cower up and maybe don't ask the questions that need to be asked or pay attention to. Right? As attorneys, our best skill is listening, and it's hard when your life's on the line, I would imagine, to listen to what's going on in the court.
Especially objectively. Right? Instead of arguing with the facts that are presented, as a lawyer, that's one of the benefits of neutrality, is that you can step back, objectively look at facts, look at evidence, how it's going to play. You have an audience, it's your jury. And so when you get to trial, I think it's really obvious. I think the impact and influence on the judge and that relationship, all that pre-trial litigation that goes on, I think that if you have a judge that can maintain their composure, especially with a very emotional,
she might be if it's in between.
Citizen accused, then
I don't know. Someone check the call and see if she's in front of Middleton right now.
Judges that just can't hold it together for good cause. That the clients have gone off ballistic, they've gotten physical, they've gotten loud, they've gotten insulting to both the district attorney and the
I would
judge.
totally have Debbie on for this.
You
And
still
she
have
is
45 cases
familiar with the case to be perfect, but she can't.
pro-pers
She's a
take
prosecutor.
longer.
It's during
They
the
take
day.
substantially longer because you have to build that record to make sure that everything is
This
knowingly
YouTube is better if you
waived,
have your own firm and
everybody's
no
on the
one
same
can
page.
squawk at you.
But the other thing that I love that court,
I mean, they can
and
squawk,
you can
but
see
you
it
don't
in the
care.
judge. You can see it from the bench. You can see that they're looking at the district attorney saying, "Hey, you still have all your discovery obligations, and you have all of these file review obligations and things that you have to turn over." And the district attorneys are very used to dealing with other attorneys. They don't have to redact things. They don't have to, and they don't have to, have criminal defendants into their office to do.
Starting in 17 minutes.
Do the district attorneys have an
Legal
obligation
Vices is in the house.
treat pro pers better if
All
they
the way
miss
from
something,
Korea.
if they miss some objection or something, or can they take advantage for pro per?
I would like to think that they would be, be a little more fair or a little more patient with the person. I mean, it's not. I can't stand dealing with prosecutors, and you know them. Probably don't need to name names, but there's some that care more about winning, maybe than being.
It got a
fair,
little warm
and
with
there's
you,
others that I
Aspen.
believe that are fair and reasonable, and so I always appreciate that.
But it is at the beginning of the video.
They're a little bit more fair. If someone
That was my
doesn't really
first
understand that they
sneak
wouldn't
attack early
take
start that I
advantage
can
of it. I'm
recall.
not saying that they need to roll over. Obviously, they've got their job to do too, and they can.
It is. It's a lot of
certainly
talk
do it,
time.
But I think
We don't have
I'd
much
like
to
to
talk
think they
about
would be
yet,
a
but that's
little-
okay.
take that into consideration and be fair. But
And I see a giggle here.
Oh, I'm sorry. I will always giggle.
I'm a dreamer. Can't take
You're
that
a
away from
dreamer.
me.
You are a dreamer. But no, and to your point, and I have said this. I think I learned it in law school. You can't teach somebody to be ethical. Okay.
Yeah.
So to your point that some prosecutors want to win at all costs. They've shown their ethical card long before a pro per ever showed up. And those that are fair and
It's
would
possible.
always
It's
be fair and respectful and courteous, I think it's more just a pain because they understand that they have to slow down. They have to do all the things to make sure that the pro per understands what's going on, because number one, they don't want reversal, right? They don't want, and they believe that you have that right. I mean, even though it's a pain,
his sentencing is scheduled for
down,
today.
And if everybody
I
went
did a whole
pro
video
per,
on this
we would
with
not know, the
Deborah
system would
Davis,
collapse, right?
and it looks like there's a year minimum. That's what
I
what I'm
honestly believe
giving.
that it would take. You would have to triple.
Tell me in the
and
chat what you
quadruple
think. Do you
course
think he
just
walks?
because
Do you
of
think
the
he
time.
somehow gets a
And then
miracle
imagine all the
probation?
appeals, and imagine all,
Or
it
or
would
they
really
suspend the
push
sentence or
things that the
something? I
system
think he
doesn't
gets
want.
a
And
year in
so I
prison,
think for
less
district attorneys, I think I've seen some that are
credit for
very
time
fair,
served because he
remarkably
served time
fair.
during
So
this
far
for
that,
going in for.
They're like, I don't want to convey this offer without having.
Frankly,
a
I think out of
attorney
contempt
present,
because he
even though
couldn't
you have a
couldn't
right
get his
to, and they
valuation.
do it every day. They deal cases with underrepresented people all the time. Yeah.
But they go into courtroom wanting to
2
win.
years. That's certainly within the guidelines.
I'm sure.
And I think in my own practice, with having done this for a long
We have a
time,
vote for probation.
we don't send new attorneys in to do capital.
See, that's
You
what's
have to have some
interesting
experience
about
under your
this.
belt
As a
because
judge,
new
if I look at
attorneys
Kim
tend to be taken
Blandino,
advantage of.
and I like Kim,
And I
he's been
think
on
about how
the
much
show.
worse
I
that
like
would
him.
be
He's
without a law
older.
degree.
He's
And
ultimately
without
harmless. Like
someone
you don't think he's
to
going to
help
go on a
shepherd
shooting
you
spree or
through
something
the
awful. So you don't have that sort of
and help you make a
concern.
record. We talked about making a
Which
record
makes you just want
beforehand.
to not do too much.
How do
to
pro
him,
pers do with that?
on one hand. On the other hand,
It
he has it
depends.
coming to
I
him. He
actually
would not stop.
represented
He
a man
he
from Chicago
has gone out of his
who
way
went
to get in
pro
trouble.
per jury trial and
So
beat
you
his
almost
case.
have to give him some. It's a hard
So
one to sentence.
as rare
It'll be
as
interesting to
as
see
that
what,
is, I actually
Judge Levitt
represented
thoughts.
a gentleman who had gone from Chicago, had a very serious attempted murder case. I was at the public defender's office, and the very first thing he said was, "You don't need a lawyer."
Right.
I don't need a lawyer. I don't need you. And I stopped. I said, "Hold on a second. Do you know who I am?" And he stopped and looked at me. He said, "No." And I said, "But I don't know who you are." So, always turn the card. And I let him talk about how he was in Chicago, had lived his whole life there, had come to Vegas for a family issue, got into trouble here. But
That's another good
Chicago.
bet.
I verified it. He had.
That's another good
And
bet.
said,
I
well,
mean,
why
I don't
don't
know
you
if
think you'd be
it-
a lawyer. He's like, well,
I
I've
don't
been
know
in
if he
and out of
can
the system so many
pass on the
times.
chance to.
I knew exactly what and he had.
To
but
misbehave
I
here.
knew exactly
It's
what I
too
needed to do,
juicy
and
for
I've
him.
beat it before. I've done this before. I don't need it. And I just explained to him the excellent work. I don't dismiss this.
Right.
I've confirmed this. And in fact, I think that's amazing. Like, it rarely happens. But how many times have you done it in Nevada?
Yeah.
And he was like, oh, well,
You'd be right to do
I-
so.
well, the procedure's different here.
Yeah.
And you don't know what's going on here. I said, how about you just try my services? And if you don't like it at any time, you have, and I've told clients constantly, I will send them Ferretta if they want to represent themselves. It is your right. And so it's not me to say that I know better. You want to deal with the consequences? Everybody's
That's
an adult
encouraging.
and incompetent. And so there you go, and let the ship sail where they may. But once he saw what I could do, he was very pleased. He accepted my services, and we resolved the case to excellent resolution.
So procedurally, how
Chili
would
would be
that
better
work?
off with
I'm
Kim at
accused
the
of a
helm than
crime,
himself,
and I come into
for
a
sure.
courtroom, and somebody's appointed, a public defender or appointed counsel.
Although Chile did file a
What's the
federal
difference between
lawsuit,
the two,
but
by
I
the way?
think it'll be dismissed
All
shortly if it hasn't
publicly
already. I should probably
provided
have
attorneys
you
are
send you look that up on
Public
Pacer.
defenders handle the general public. Track attorneys will handle the conflicts from the public defender's office because there's so many clients, there's so many people, so many defendants, and you can't represent a
Seriously, Mike,
defendant
Judge
where
Levitt really
the
has to
victim
think
is a
about
previous client of
Law
yours,
Talk with
right?
Mike
Because
in
there's
their
so many
audience,
lawyers,
in his
you
audience.
multiply
Yeah,
that. You have track lawyers,
multiple defendants,
multiple co-defendants, that sort of issue.
Bring
and
out-
then you also have the special public defender's office
Bring on
here for those
main show here.
felonies and above, life tails, those sort of cases that work as a systematic conflict for the
Yeah,
public
that was
defender's
long
office.
ago.
Here in Clark County, we've got 110, give or take, public defenders and another 15 or 20 special public defenders, office of appointed counsel, and track attorneys, probably double that number, close to.
Yeah, about that.
Yeah. What close? How does that work with the public defender's office? We're talking about conflicts. I've represented somebody on a drug case and they're a witness in a case you're going to pick up on an attempt murder. Does that mean you can't take that attempt murder if you're in the same office as me?
Yes,
What we're talking
that's exactly it. So our ethical obligations to a client exist after our relationship with that client exists. As a lawyer, I cannot defend somebody where it would require me to cross-examine a prior client because I know everything about
Nova
that client,
Scotia.
right?
Oh,
I've got all the dirt. I know the
We got Iceland and
I
Nova
know
Scotia.
the truth, right?
Know where
I
the
know
bodies are
drug
buried?
issues.
Where the bodies are buried?
I know where the bodies are buried. So, I mean, and imagine what kind of relationship
it.
anybody could ever
I know
develop with
Finland's
a
in the
lawyer
house,
when
too.
they knew that you could turn around and use it against you. So, I mean, the system works. I mean, the point of the system works as long as everybody respects it.
So if I'm a defendant and I come into courtroom and I don't want my public defender, should I ask for an appointed attorney? Am I going to do better with an appointed attorney?
I haven't seen that one yet. I haven't seen
You
that
don't
one.
get the choice. It's not that
I'm sure it's fantastic.
Talk about it a little bit. How's that work?
Well, they have to qualify for the public defender. I'm not exactly sure what the number is, whatever that would qualify someone for the public defender, but there has to be a need if someone earns.
Well, that would be a good idea. I think
own a
I think
house and a
Chile
plane, they're
wins
not
that
going to
fight
get the
physically.
They're in custody.
He's younger
Oh
than
yeah,
better shape.
when I
There's
was
no
in the
doubt
PD's
about it.
office, I'd walk out and had a client get in the Maserati.
If you had one,
I was not happy.
If you had to have
I was
one
not
that
happy,
actually,
but I have had that happen.
doing law,
If I go out and I,
it's not
hire
good either
Mr.
way.
Payne,
But I
and I don't like what he's doing for me, and I doubt that would be the case. But if it were the case, I go to Miss May, walk down the street and hire a different attorney, correct, or Miss Miller?
Yep.
Does it work
Thank
the
you.
same way if counsel is appointed?
No.
How do I go about getting rid of my
I had it on.
appointed counsel if I don't care for them?
But it got a little stuffy.
So you get in the
Would it
mail
make y'all
a
feel better if I
handwritten
just buzzed up for a minute?
pleading,
Just
saying,
buzz up?
motion to dismiss
That's easier.
counsel because they haven't come and seen me in 2 days or whatever it is.
Because it
They
has nothing
haven't
to do with
given me
any of
my
this, but
discovery.
that's
They haven't
okay.
done this. They're not doing anything for
They're
me.
not
It helps
answering
me get
my
it
calls
helps me
Yeah,
get
4 o'clock in the
to
morning.
So they can. That is usually
special law talk with Mike,
the
please.
one motion that will get through, not treated as a fugitive document and gets through and gets put before the judge. A lot of times it's just that they want to hear from you. It's a balance. Their case is their only case. And I mean, I do tell this to my clients all the time.
All right,
I budget my own time, and I understand your case.
You can't hear me?
It's important to you. It's important to me, but so is everyone else's case. And your case is 3 months out. I've got one that's set for trial next
Try
week.
this.
It's either gonna, So, excuse me if I haven't been here, but I'm not neglecting you. It's all a balance. It's sometimes it's difficult.
Can you hear me now?
So sometimes you can smooth things over. If not,
Can you hear me now?
You say, look, I don't have any opposition to this person's motion, but they have to file a motion. There has to be cause, obviously, and
I can't hear this.
Sometimes
I can't hear
I'll
the
do
stream
it
at all.
on rare occasion, but I've done it where they just refuse to.
Super quiet on my
So
end.
they've just decided that I am not helping them, or I'm not competent, or I'm just not. It's just kind of fold their arms, shake their head, and I'm not answering your questions. I'm not going to help you at that point.
A breakdown in the relationship.
Yeah.
Do you have to air your dirty laundry in front of the court, or how does that work?
You got to keep it classy. I mean, I never like that look when I see attorneys do that. You're still your client, and I don't understand the point of that. But sometimes I think personalities, both sides, get in the way of good behavior, good public behavior. But
And here in Nevada, we've got something called a young hearing, right? And that goes to a breakdown in the relationship between
A material breakdown of the relationship, yes.
between the attorney and the client. And a young hearing would take place outside the presence of the district attorney, so we can avoid
Thank
having
you, Chuck.
to
I think
air the dirty laundry.
air the dirty laundry. Of course, you still have the dispute in front of the judge, I suppose, and that may not be a good look at that.
Yeah. I don't know how to do
Sometimes, usually, I think most judges
if I had
when you
a
sort of put the,
if I had a good
because
fence
obviously you still
dispenser,
have the obligation to
I
protect
would set that up
privileged
in March.
information
Exactly.
and things like that. So usually I think judges know when you put the language, communication is broken down, or there's certain, I don't know, I call them
I sure do.
dogmas, certain
I don't know how to
phrases that
use
you
it,
put in
but
there that
I've got
the
one.
judge understands. Okay, there's something that obviously he can't divulge, and so, and it's usually both parties at that point.
Secret Squirrel can
unless
tell you where it's
they
at
agree,
if she's around.
Granted the motion to withdraw.
Yeah, and I think that now I have my civil hat on because I don't do criminal law as a, unless I'm the forensic accountant. I've just covered really mostly for David Fisher. But on the civil, there's I think there's 4 criteria, but they're given from the professional rules of conduct.
And that brings up an interesting point. If you're hired as an attorney and you don't get paid, that's
you're lucky you dodged that bullet.
I think it also depends upon how far you are into the trial. That mixed with somebody wanting to now go pro se so close to the trial, that may be grounds for the judge to say, no, it's too
Thank you,
now
Mark.
into the trial or close to
10
the trial.
pounds.
Well, and I
Scottish
think
law
that's
nerd. All
I've
right.
got a
1 year
capital case
suspended
right now
is,
for
I think, is a good guess.
fabulous
I don't know if they
relationship with a defendant who's willing to
I don't know if they can, but they
represent himself
probably
in a
can.
capital trial despite my best advice. And those
I can see that.
those
They just
things
want to hang it
happen,
over him
and
so
in
that if he does
situation, I
anything,
am
they
going
can
to
yank
be,
him right
I think,
in.
appointed standby.
That would make
counsel.
some
That's
sense.
what the court has said. And that's a little different than what we've been talking about with pro se. Pro se is essentially just coming in and you're by yourself on your own.
Sounds
But
like
there's kind of a
you've been
in between situation with standby counsel. Let's talk about that a little bit. How does that work?
Well, depending on your jurisdiction and which judge. So I think that there's been a pretty clear confusion between the terms standby counsel and elbow counsel. And I think traditionally those have been considered differently.
Thank you, LB
Of
Dubs.
course, whenever
It's
a
getting
judge
better day at a
appoints
time. It really
an
is. Thank
attorney
you.
to a client, there has to be a conversation. There needs to be a conversation on the record if it's anything other than the traditional attorney-client relationship, because I think not only from the case law but just in practice,
who's this
as
Kathy
an attorney,
Viking Queen?
you need to know what your parameters are.
I know not of what
And
you speak.
standby counsel, I think, for all
Conscious
of
expression,
history,
$50.
has been
Thank you. Here's
considered
my
counsel
related
that stands
tip for
by
the
ready
JDAH
to
coverage.
jump
And
in
yes,
take over a case
we can hear you fine. The
whenever
boys
the
deserve
judge
some
determines that
scratches.
it's appropriate.
Oh.
Whereas
Well,
elbow
I don't know if they
counsel,
deserve them, but they get
and-
them. They get them.
Well, if I
Thank
was
you so
standby
much. That's
counsel
very
and I
generous.
was given the time, preparation, and all the due, all the bells and whistles that come along with being counsel of record, meaning I've just had done the discovery, I've interviewed the witnesses, I've done everything I would to prep for that trial. I don't have a problem with being standby counsel because I think.
Okay, is that a live
standby,
shot behind the
truly
panel?
standby, because at the
That's-
point that the
I'm
client
trying to figure
freaks
out, but I've got
or
a small
has
screen here to
I
look
can just
at.
pop in and go. Elbow counsel, I think, is a very murky place.
And you're talking about hybrid counsel.
So what these elbow counsels, and so to me, the way I've always contemplated elbow counsel is that I am sitting at your elbow, whispering in your ear if you ask it, or if if
Is
you
it
have
happening?
the question as the client, and you're my client now. If
Do
you
we
have
have
a
an
question
ascot
about
sighting?
procedure, or if I see
Well, I would
some-
like you to represent me then.
Really?
You do better than I will.
So,
Please.
so like a question about the procedure or an objection should be made, I'm at your elbow. I'm
It's got
advising
that
you can take advice or not.
crappy authenticity
But
to it.
ultimately, with any of these, before I'm tagged in as standby counsel, every single decision is the client's decision. And when you're the attorney, every single decision is not the client's decision. Very few decisions are actually the client's decision. But when the client is leading the representation, the clients, the attorneys, and the judge themselves to actually very clearly
Thank you, old
define
dog.
what the client is getting, what the client is not getting,
All right.
the obligations.
I'm going to do this
counsel,
like a
what is
rain
not the
dance to make
obligations
it
of counsel.
start. Let's see how that works.
Can I have somebody take over? Is that more difficult?
Thanks again,
It is more
Kim,
difficult
and
because
Kick.
the attorney, I think, comes in and says mistrial.
The gift that
right?
keeps giving.
Like if I'm the attorney of record, I'm protecting the procedural process, which I don't think a judge is going to want. But I don't know. What do you think?
Boy, that would be a nightmare scenario. And I'll be honest, I had a different understanding of either elbow counsel and standby counsel, really just two words for the same thing. I know when the first time I was appointed, it was Drew Christensen told me, hey, this person's been, had the Ferretta canvas. They're their own attorney. You don't give them legal advice. What you're going to do is help them with things procedurally, help them, if they need help with, formatting or the subpoenas, how to do those things. But all those decisions are theirs and not yours. And so that being said, I wouldn't want to, especially if I had a major disagreement with the trial strategy of the pro se, I wouldn't want to jump in, 3 days after trial on a trial strategy that's not mine that I disagree with. Yeah, that would, like I said.
How about a client with mental illness as an example? And that's kind of common in pro pers, I hate to say, but a client with mental illness who's decided not to consult any mental health experts, and you get 3 days into trial, and that would have been your strategy if you were the attorney.
Right,
Thank you, Truly Jupiter.
You continue this 21 days so I can give notice of my expert witness.
Well, it's so counterintuitive because if you think about it, you have to go back to what you said in the beginning of this. This is
Interesting. What makes you think that, Thomas?
This isn't like
and thank you.
Another choice of counsel. This is your right. So with your example, with that judge saying no,
there's a
legal
case
advice,
going on.
Okay, that's it. That I think protects the record with every single decision made, whether you perjure yourself or not. You don't want to get any kind of expert. That's your right. It's not your choice. It's your right. And that, I think, if you put it in that your constitutional right to screw everything up for yourself.
Not yet, Casey. We're still waiting for it to get called.
So then if they decide to get an attorney and you come on and say mistrial, of course, I've never experienced that, but I don't think the judge would, I don't even think an appellate court would look at an attorney.
I prefer the other case.
In fact, I don't think that would apply.
Oh, it doesn't.
You can't protect yourself, represent yourself, and then say, "Sorry, ineffective against assistance of counsel." Me, you can't do that. It's like
so you've given that up.
Well,
as long as he has an avenue for appeal,
it behooves everybody to make sure it's really clear on the record.
Yeah.
Because I have seen attorneys say, "Okay, I'll be elbow counsel," and then
that's viable that I can see.
I'm out, and they're like, "Well, I'm just your elbow counsel. I'm not prepared to step in."
Right.
So I think that especially Nevada really doesn't have statutes or rules about how this works, and just across the country, there's so much varied law about it. But it is if you're talking about a jury trial at that point, it is the district court's responsibility to make sure that all the litigants understand what you're waiving, what you're giving up. That's part of the Ferretta canvas. So I don't think the person representing themselves could say, okay, now I want a mistrial. I messed all this up. But I think as an attorney, procedurally, you do the work. Okay, it's going to be denied, granted. But then you deal with the cards that are dealt.
No, you know what? On The Good Wife, she did represent this wacky client, and he represented himself. And I just remember it was the impatience and how he wanted to represent himself, and he was just like this, just really bad defendant. and she was standby
Oh,
counsel.
Judge Levitt, after all we've been
I just
through.
remember
The drunk guy in court,
the
all the
humor
Kim
in that, of
Blandino
the
stuff.
impatience. So you just want to clobber the
Come
person.
on, call it out for me.
Yeah, not to tag anybody as being a good or bad defendant. I mean, not my
place.
But being a public defender for 30 years, I don't pick and choose my
This was on TV, so.
What is there any group, and I'm looking for an answer here, that goes towards pro per more than another?
Sovereign citizens, bing!
Bang.
Sovereign
Tell
citizens.
me about that. Tell me how that works.
Oh.
Play Zoom, I'll do it.
Okay. Well, what do you know about maritime law and admiralty?
I actually used to have a sailboat, so I know a little bit about
Kathy
that.
Viking
But,
asked a
no,
question.
No,
All right.
no, that's so basically
Did I miss it?
sovereign citizen movement.
There's a lot in the chat.
Has grown, I think, out of Wikipedia, but it is this belief that you are.
Thank you all for keeping this project afloat while we wait.
We're not ruled by a monarchy. That we can basically.
I just don't have rooms of material.
Throw out all U.S. law. For a court to be able to rule over you, they have to have jurisdiction, right, over the subject matter, the place, and the person, right? So basically, once they figured out that's just law 101, they object to the jurisdiction.
That would make
over
a lot
the
of
person.
sense.
So there is.
Yes, if I'm the judge, if I have a call, he's last on it for sure.
Through whether it's through
Given
our
his history.
prior our treaties. Our maritime law.
No.
There's all these other different theories that the United States government or Clark County government or wherever you're residing does not have physical control over the person that you are. And so because you are a sovereign, you are your own king of the citizen of the land that you reside in your body, that no one else has any authority over you. So because the court does not have jurisdiction over your sovereignty, over this royal we that we are, that they can, everything that the court is doing is improper.
Are they ever successful?
Yes.
Well, yeah, I know there was one video. The guy just said, yes, he did not consent. I've seen the video that did not consent because basically it's sort of an extension of what, my political science degree finally came into play and worth something. But the concept of natural rights, obviously, and in the Declaration of Independence, that those rights are of our life, our liberty. They didn't come from government; we are born with them. And so then, since they didn't consent or opt into this sort of social contract or this government, that they're exempt because of that. And I did. There was a ticket in municipal court, and the city attorney was dealing with this guy. He's asked me, "Can you talk to this guy just as a favor to me?" So she's like, "Yeah, he's just." So he's telling me, yes, he was a vessel in the course of commerce, his car, and so maritime law was applicable. And I'm like, well. You're also driving
I can see that
on the streets of the incorporated city.
I can see that. That would be epic.
Las Vegas. So yes, this judge does have jurisdiction over him,
and not completely out of line.
Yeah,
with what we've seen so far.
Admiralty law, and he's exempt from doing it, and it's just bizarre. I don't know how anyone thinks living here in society that they're exempt from.
And to be honest, I've seen it, and oftentimes it derails the process in a way where it goes completely away from
we might want to take
the allegations, and the people end up in prison. And some of the times on the bad end of things from the judge, also, who tends to be frustrated with shenanigans.
It's considered shenanigans, but I have seen it very, very successful. I don't know.
Not a bad idea there, Secret Squirrel. I think I'll do just that. This way, I mean, that's what it is. I just have it on to maintain a visual so that when they actually call the case. Because I will space out and miss it if I get to chatting with you. A popular move. Stop it, Peter. It really is. Although I couldn't hear it much. It was just mild distraction in the background. I don't know if you guys are going to be able to hear it. Story time? Well, I don't have any stories. I don't have any stories handy. All right, I got a story. I woke up this morning. I got a vicious cold, but I thought I really just want to take cold medicine and conk out. And then I thought, well, it's Blandino sentencing, and you've been telling everyone you're going to live stream it. So here I am, the end. Was that fascinating? What's loud? Am I loud or is the feed loud? Yeah. I have a little diet soda mixed with lemonade. It's pretty exciting. It's definitely too early for happy hour. That is for sure. Thank you, Casey. You like that? You like that blatant cry for sympathy, and it worked. You're the best. You're the best. I'll be fine. But I don't know why. And it's warm. It's July here, and I woke up and I just had the most vicious cold going. It'll all pass over. It won't be a good deal. A big deal. But that's where I'm at. Need a hot toddy? I'm a big fan of just plain ginger. Ginger and boiling water. When I'm sick, that's the stuff. That's my drink of choice under the circumstances. Problem is I don't have any ginger. Does anyone want to bring some over? Oh, I can. I think he's going to get a 1 year prison sentence, less credit for time served, but I don't know. I mean, like, he's older and sort of harmless, so it's not like he's really a danger to society. So I could see them giving him a break. But if the chat is right, and you guys 99 times out of 100 are, he filed another motion for a change of judge yesterday. I mean, if that doesn't say put me in jail, I don't know what does. He sure is. I've never done. Kim Blandino is the one who really. I'd done live streams before, but that really pushed me over the top because I was trying to cover that, and I kept streaming it, and I would do these long streams, which I've never done before. It's And yeah, I'm not gonna lie, I might have had a few cocktails during the trial. All right, Megan Pot Pie's arrived. Come on, Judge, call the case. I suspect that's a good that's a good recipe. I've done ginger lemon. I don't know about the sage and cloves though. I don't know about sage and cloves. That doesn't sound like it tastes good. Ginger itself tastes good, at least to me. I just like ginger and lemon. Good stuff. Well, I can. I put a link to a video, but we got nothing but time. So I got into this because he was doing crazy stuff. He's been a crazy litigant for a long time. But what started this is he got convicted of a traffic ticket. Some offense. I don't even know what it was, but I'm sure he was guilty of sin. The judge, was it Federico, came to the obvious conclusion that he's guilty of this traffic offense, and he has not been able to let it go. So he's been hassling that judge, shows up at his office, files motions, does all kinds of stuff. Gets charged with extortion with respect to that, and which is just a tough charge to prove, but they did prove it, and then he basically acted it out in court. And so they came back with a verdict of guilty on this. So this is where we are. Ben Bateman did a really good job. I think Ben could have gotten him off if he would have listened to him, but he didn't, just because it's a hard charge to prove. But he had no control over his client, and here we are. But the multiple motions to change judge and all of his courtroom antics are pretty good. The judge who told him not to act like an a-hole right to his face in court, who I believe is now in the Nevada Supreme Court. I mean, there are so many good nuggets in that playlist. I'm here supporting my own playlist, but I'm not gonna lie to you, it's good. It's good stuff. Come on now, people. Let's do this. Yeah, Naomi, I think that's it. Let's keep it down to 3 ingredients that I can handle. Sage. I mean, what does sage taste like? That just sounds like nasty plant. No, it's not on the table. Unclean hands. Now knock it off. Good to see you in the house. Yeah, I think you're right. Although it didn't work last time, we're going to do it again. How many dances do we get in before he calls the damn case? Fate worse than death. I should test myself for what? Now that would be good. All proceeds going to charity. That I could get behind because he's got a dancing gift, and the world needs to see more of it. Oh, I don't even have a sense if he's in the court. Has there been any sighting of him yet? I didn't read your other super chat. Oh, I'm sorry. Thank you, Jeff. Also, I wish the closed captions were on for the courtroom so we could see Judge exasperated sigh. Okay, so let's have Blandino in here. All right, let me see if I can turn that on. Let me see if I can turn that on. It said captions not available. I mean, you guys can probably see it. I don't know. I'm not making it up. That's what it said. The Wanda Life. $49.99. Thank you. Mike, congratulations on your 100+ video. I really enjoy your content and personality. Keep up the great work. Thank you so much. Test yourself for Blandino 19. I haven't had any physical contact with Blandino. I think I'm okay. Unless it came through when I chatted with him on my channel. Yeah, seriously. And thank you for the $5. Oh, thank you, J-Car. Oh, I mean, it's relevant if you have, I don't, if you have COVID-19, which I don't think I do, but if it wouldn't change anything I did. I mean, I'm staying out of people's way, and that's it. That's what you do for a cold. That's what you do for that. Joshua Lee, $10. You missed mine as well. I was wondering if they can limit appeals to Kim's vexatious litigant history due to, well, they can sort of prevent him. The problem with the vexatious litigant thing is that is going to be primarily based on a civil action because of the vexatiousness is someone who keeps bringing civil actions. When it gets down to criminal defense, you can try anything you want. And I don't think they're ever going to be able to limit it on that basis. I think they're just going to slap them down and say they don't make sense or whatever. there's all sorts of repetitive and low probability appeals emanating out of criminal actions, and the courts never stop that. They just rule against you, and that's it. It's another thing altogether to use the court system to seek monetary damages in the civil context, and keep doing that to harass people. I mean, I think the idea is obvious that of course, people do whatever they can to defend themselves. But if you're bringing a civil case as a plaintiff, there should be some reasonable basis for it. Oh, I would like to think that, but they also probably have a call going right now, which I should probably go to in the meantime. I mean, who knows what's going on in Judge Ron Hell's courtroom or Judge Simpson's courtroom right now. We got naked litigants and people talking back. Denise Bryant's probably going off about marijuana on somebody right now. Come on, they are clearing that whole call. Well, if that's the test, it's a cold. I think that's awesome. I do think that's awesome, and it gives the whole chat a nice visual. Hi Sam, I am. How you doing? Nice to see you. Don't worry about it. You haven't missed anything. We're just waiting around for our good buddy Kim to get called up. Ooh, good to know. Good to know. Okay, that's odd. I'd like to hear the rest of that story. I don't know. I don't know, Veronica. They're laughing at me. Oh, Judge Middleton's done this to me too, though. What is it? I did a wild goose chase, and I can't remember who I was. It was probably Samir Siraj Bay I wanted to catch or something like that. I sat over there for a half hour, and they never called the case. I can't remember. I can't remember what the maximum is. I did a whole video on it with Deborah. I put it in my community tab. I don't know if you guys can find the community tab, but it's in the center at the top. Anyway, Deborah learned that she has looked up the statute and gave the whole thing when we were discussing it. I can't remember now off the top of my head, though. I think it might be up to 4 years or something like that. Lori Lightfoot said that Chicago needs fewer Kim Blandinos. Did that actually happen? I mean, I don't know if you're just making a joke if that actually happened. I wouldn't know that Lori Lightfoot would be aware of Kim Blandino. I can assure you that Chicago could use less Lori Lightfoots. That's for sure. That is for sure. Yeah, Kate, that was my, I don't think she's hip to that. She's sort of the definition of not cool. Well, Sam, I did have the ascot on earlier. You know, if you arrived on time, you would have seen it. That's all I'm saying. Oh, he couldn't serve that sentence. There's no way. There's no way. Is this happening? Are we there now? Oh. Oh, I didn't know Nick had a Pope hat, but it sounds like him. Yeah. It sounds like something he would do. For some reason, I feel like electing Justice Goody. Seriously, show some respect. We've got international attention here. I gotta go find the clip. Oh, let me see if I can get that.
Received international attention.
International attention.
Ah, thank you, Derek. Oh, come on. I first of all, thank you all for hanging with me. I'm still having fun. I did do an ascot. I did the lazy job of tying it, but then I got hot. All right, Fez is a little easier. I can do the Fez. I don't have to tie the Fez. Well, it's just not the first case on the call. I would have thought they would specially set this, like not just have it as the only case on the call. I can't take myself seriously to discuss it. I was like having a real thought, and then I looked over and see myself in this Fez. I can't deal with it. I can't. No, I'm surprised they didn't. You know, if I'm judge, I would just say, all right, let's do this at 1:00 in the afternoon. It's the only case at 1:00 in the afternoon. I don't want anyone else in the courtroom. The bailiff, the defendant, his attorney, me, the prosecutor. Let's go. might have to go that direction. Well, that's what I'm going to do. I'm going to try. I'm going to try the good method, and if that doesn't work, and I can't sleep, then I'll just do a happy hour tonight, tie one on, and pass out. That's my plan B. I'm going ginger and lemon for the first attempt at conking myself out. I think that'll do it. That's true. A special setting would be perceived as a sign of his nobility. Well said, Armin.
Received international attention.
International attention.
A contempt charge is a strong possibility. Depends how fired up Kim is when he rolls into court today. We know he's capable of it. It just depends on his mood. Yeah, the ascot in court. That would be bold. That would be bold. I'm trying to think. Would that work? I mean, it's a tie. I mean, Kim did it. I don't really think they could go at you and say it's not appropriate to tie her. You just say, hey, I like ascots. It's a sort of tie. It's formal attire, and here I am. Oh, the judges would not be able to take me seriously. All right. Come on. We've done an hour now waiting for this to get called up. I mean, this is getting outrageous. Outrageous, I tell you. It actually makes me miss this.
Good morning. All right. Okay. I am Judge Lanice Bryant. Welcome to the 36th District Court. You are at the 36th District Court. You are at 36th District Court. You are at 36th. Where are we, Judge? Court. You are at 36th District Court.
Thank you, Big Smoke.
You have lost.
Oh, Lord. Oh, Lord. I doubt it, but that's even possible. Thank you, Hood Tours. That would be fun. That would be fun. Yes, I think Alex seems to be in the know about those things. He's got a lot of connections out there. I mean, he doesn't know everything, but I think if they knew that this wasn't going to go on, he would have said something. But you know what? Let me check my phone just make sure there's a message from him. Nope. And they usually go. They're usually live. They usually sit in the courtroom, which is strange to me when this stuff is happening. At least they were doing it during the trial. So if something weird was going on, he would know because he'd be talking to everybody there. Even if they get pan around, I could get a sense of what's going on. I don't see Ben either. There's the prosecutor. I forget his name right now. I was trying to get him on too. It just escapes me right now. What's the prosecutor's name? Somebody in the chat tell me. There's Ben. Oh, this is about to happen, people. This is about to happen.
So I'm fine, whatever you want. I'm fine hanging out.
We can go forward. I want to bring out speakers. Is he here? I'm assuming he's
Yes,
here.
yes, he is here.
Can you hear? Because I can't. Yes, Dickerson. That's right.
He's here in the courtroom, and this is on for sentencing. Mr. Blandino, do you know of any legal cause or reason why judgment should not be pronounced against you at this time?
Yes, I know many reasons. There's a motion to disqualify held against you in the rear that's parallel. But let me enter my appearance. King Blandino. I filed a motion to disqualify based on new information.
Oh yeah.
Very serious stuff. As you know, there have been investigations.
You're represented by counsel.
Yeah.
Anything that you don't allow is-
There's a motion for new trial as well. That's pending.
You did a document. You did a document.
But as far as I know, there's a
You're not
placeholder
permitted
there.
to
You're
file you're not permitted to file any pleadings because you are represented by counsel.
That does not mean, Judge, that an attorney, if you force counsel on me, either here now, which you're doing, or when Mr. Gerstmann, who's a purported appellate counsel or post-verdict counsel.
Ah.
Post-trial counsel.
So that's his appellate attorney to his left.
And ask to amend that motion for new trial because, as you know, under the law, unless we file within 7 days, you cannot move forward with sentencing. Oh, wait, Debbie, hold on. Debbie,
there's a few housekeeping matters I can speak to the prosecutor before, just regarding the PSI. But with them, when had after the seeking the new PSI issues, I don't think that's necessary. I think we can clean those up. There's just a couple of, the main issue, Judge, was the credible time served that was listed in the PSI is unfortunately, it was a judge explaining they had 200 days between levels. Yeah, we have it calculated as 134 days credit time served.
That's correct, Your Honor.
Additionally, I believe, I don't know what page it is, they listed Ms. Pendergraft, the man of whom Mr. Blandino is the caretaker, as his mother. She's obviously not his mother. And the ages of his children are wrong. I believe they're off by a year. They have each
Okay.
a year younger. And then, yes, he did, I believe this one is splitting hairs, but I will bring this up to Mr. Blandino that they listed Mr. Marvin. So I believe it's here in the court today. Listed him as an FBI agent, and I know that he is a city marshal. He did testify that he's deputized and on an FBI task force, so calling him an FBI agent is splitting hairs in my opinion, but I think it's
Okay, wait, say that again, say that again.
It's not FBI agent.
I can clarify, Your Honor, specifically as of page 5 of PSI, paragraph 6 down. It indicates that on April 29, 2019, the officer of the Federal Bureau of Investigation later identified victim 2. So in that portion, it's identifying the detectives that were involved in this investigation as officers of the Federal Bureau of Investigation, which in fact they were. They were both task force officers with the Federal Bureau of Investigation.
That's not
with the Joint Terrorism Task Force.
Yeah.
And so that's actually very accurate. It doesn't say they're special agents of the FBI, it says they're officers. They were task force officers.
Okay.
So I guess splitting hairs. But I believe those are the matter. So if we could have the record of the minutes reflect those corrections that should be made to this PSI.
Absolutely. So by virtue of the jury verdict returned in this matter, I hereby adjudicate you guilty of count 1, extortion, and count 2, impersonation of an officer. Does the state wish to be heard?
We do, Your Honor.
Go ahead.
Your Honor, we come before you today asking for the defendants to be incarcerated. Right off the bat, that's what I'm going to tell you we're looking for here. I think that the number one thing that sticks out is the defendant's conduct throughout the crimes that he committed in this case, throughout this case, and throughout his history. The defendant is somebody who has zero respect for the law. He's somebody that only believes that the law is here to serve him as he sees fit. Just as he sees the religion and the word of God that he interprets in the Bible is here to serve him as he sees fit. That's something that I think comes to mind when I look at his sentencing memorandum. There was a retired judge who wrote a letter in the sentencing memorandum. And, I essentially, two of the things that I noticed weren't in that particular letter that came to mind of my pre-trialing of that individual before trial, as they were noticed by the defendant as a potential witness, was that that individual had indicated that the defendant's religion was whatever he wanted it to be, essentially. And further indicated that in talking with the defendant over all these years and seeing his interest in the law, the question had come up, well, why did you become a lawyer, Mr. Blandino? Well, the response that was reiterated to me by Kim Blandino was, well, then I would have to follow all the rules, and I don't want to do that. That's exactly the case. Is Mr. Blandino thinks that he can go around doing whatever he wants, coming into these courts and petitioning inappropriately, making inappropriate appearances, making inappropriate filings, and making inappropriate contact with judges, and he thinks he can do it because he doesn't have to follow the rules. Further, you look at the sentencing memorandum, I believe there's at least 3 letters in here which tend to support the defendant's unauthorized practice of law, helping other individuals left and right, him indicating to these individuals that he can help them, and all 3 of them indicating, yes, I go to Mr. Blandino for legal advice and assistance. That is something that Mr. Blandino has done.
Don't interrupt.
I need a chair and they won't let me sit down. I have a bad leg and I need to sit down.
You can sit down.
Can we sit down?
Sure.
Thank you.
Have a seat.
Thank you very much.
You bet.
Here in this particular case, Your Honor, the defendant repeatedly contacted Michael Federico, pro tem judge,
the city of Las Vegas in an attempt to influence his actions in his capacity as a pro tem judge. In doing so, he caused Mr. Federico and his family immense fear, to the point where Mr. Federico has since moved out of this jurisdiction. You heard from him at trial. As a result of what was going on, he was carrying a firearm around him. Him and his wife were worried about the path that their children had to take to school. Extremely concerning, and even more so, the fact that the defendant was given opportunity after opportunity to withdraw. He did not have to go down this path. He pressed forward every time that things seemed to take a lull in his mind. And what he did is he ended up upping the ante and ultimately continuing to threaten Mr. Federico and adding threats to what he was indicating he would do. Where he ultimately did make good on some of those threats, which was sending the partners of his firm a package full of everything, all the disparaging comments, everything that he had thus far been sending to Mr. Federico himself. All for what? All because he wanted to have control. He wanted to have control over Mr. Federico, Judge Pro Tem Federico in that capacity, and he wanted to influence the justice system, as we see that he does day after day when he appears in front of this court. It's, as of a couple days ago, he filed this fugitive document. This has to be, the 23rd motion to disqualify, something that he is doing for the specific purpose of inappropriately influencing the justice system, inappropriately influencing these proceedings, seeking to delay. Just as he walked in here today, seeking to delay this sentencing hearing, it makes clear why he's filed that new approximately 23rd fugitive document motion to disqualify. These are actions by the defendant that are not going to stop. These are things that are just part of who he is. And we take a look at the theories of punishment. In the American system of justice, we're dealing with really four primary theories of punishment, that being retribution, deterrence, incapacitation, and rehabilitation. Well, what becomes clear is that rehabilitation is the predominant focus for the American justice system at this point in time, given the state that we are in our current history. Rehabilitation is not an option for Mr. Blandino. We take a look back. Mr. Blandino has prior felony conviction from 1994, violation of custody rights, something he was convicted for in a bench trial. And there too are so many similarities from 1994, his acts in 1993 and before, to what he is doing now, today, decades later. And I will just reference this for the court for a bit of background, is that the United States Bankruptcy Court out of the District of Nevada had issued an opinion in 2004, a published decision by the Bankruptcy Court. This was a published decision. It's in re Bradshaw. This is Michael and Nancy Bradshaw, who had filed for bankruptcy. Nancy Bradshaw is Defendant Blandino's former common law wife, the mother of his children. She had been placed in dire circumstances as a result of the defendant's actions, and was seeking to have bankruptcy. Mr. Blandino entered that as a creditor, and ultimately the federal judge issued a scathing published opinion talking about Mr. Blandino and his history. And I think that the history that is recounted by the federal court is so similar to what we're seeing today that I have to mention it. And just for the background, the court there indicated that Nancy Bradshaw and plaintiff Kim Blandino were married, in quotes, in 1987. They had two sons, Zach and Andrew, born in 1988 and 1999. And then in 1991, they separated. That's when Nancy had petitioned the state court and was granted primary fiscal custody of both of the children. Although there was an order in effect was not introduced into evidence, there was no dispute that the boys have legally resided and remained with Nancy since that date. From the time they separated in 1991 until June 6, 1992, Kim and Nancy worked out a periodic visitation schedule. However, June 6, 1992, Kim, without explanation or warning, abducted and kidnapped both boys. Although Kim changed his identity, he was cited in Portland and eventually apprehended with the children in Phoenix, Arizona, on or about January 25th, 1993. In all, the disappearance lasted 7.5 months. The children's trauma had been exacerbated by Kim telling them that their mother was dead and that she had spiritual cancer. During that time period, Nancy had no communication with her boys whatsoever. After Mr. Blandino was ultimately convicted and sent to prison, he served a 6-year prison sentence. He gets out of prison. It was at that time that there's a domestic relations court appointed family therapist to start reintroducing him to his kids again. That therapist, after conducting numerous meetings in the process of reunification, indicated in her report to the court that Mr. Blandino conducts his life by his interpretations of the law of man and God without regard to the expectations of society in which he lives, ultimately leading to issues. And further, no surprise that Nancy was seeking to move out of the jurisdiction. The defendant at that time took further action. I think it is consistent with the behavior that we've seen here. That's when he then filed a lis pendens on their property. 3 days before Nancy's home was to sell, it collapsed. The home sale collapsed because of the lis pendens that he filed. Something that
A lis pendens on her house.
on her home, yeah, and it was totally without merit.
Is that punishing me?
No, it's
Okay.
not.
At trial, Mr. Blandino stated that the lis pendens was to stop the sale because the family court was not fast enough. He indicated here further that to another psychologist that was introduced into the case as far as reunification,
He
that
admitted to filing the lis pendens in bad faith.
he did. He admitted to the court at trial that it was for the purpose of stopping the sale because the family court was not fast enough. That's a quote from the federal judge quoting Mr. Blandino. And then further, he indicated to Dr. Gary Lenkite, who was also appointed by the court, that he referred to the kidnapping of his children as, quote, seeking self-help. Seeking self-help, Your Honor. That's what the defendant's been doing. He's been doing for decades. Inappropriate, illegal self-help. That's what he did in this case. And frankly, it's become clear that he just has no respect for the law. And so that's why I stand here today and tell you that there is no way to rehabilitate Mr. Blandino. Probation is something that is never going to be adequate for Mr. Blandino. It's never going to send a message to him. And all he's going to do is continue with his self-help and continuing to obstruct the process. So what would we even be looking at if we were looking at probation? We'd be looking at a system now that has been changed recently by the Nevada legislature that leads us to a point where Mr. Blandino could get no more than 36 months on probation. And further, the Division of Parole and Probation will be required to submit to this court a discharge at 18 months, halfway through. 18 months of probation. It is.
She probably has a good idea what she's going to do.
Punishments that have been considered and changed by the Nevada legislature that just don't work for probation in a case like this. And as a result, we take a look at the other theories. I think that retribution is a theory of punishment, essentially that the punishment must fit the crime. Here in this case, a prison sentence is a punishment that would fit the crime. The prison sentence that I'm going to ask for is a punishment that will fit the crime. And then we further go to deterrence. And under the deterrence theory of punishment, there's two separate theories, right? General deterrence and specific deterrence. The general deterrence theory of punishment being that the punishment that is handed down to Mr. Blandino will deter others from the same criminal actions and the obstructions of our justice system here in Clark County, Nevada. that's something that I think weighs heavily on the fact that there's many people who have watched this trial, who know about this case. I mean, we even have a letter in the defendant's sentencing memorandum from someone who's a fan of Mr. Blandino.
It's a very good argument.
With his fans. This is a sentence that will generally deter other people from doing the same thing, the same illegal conduct that Mr. Blandino's been doing. And then we look to specific deterrence. That's all we can hope for at this point in time for Mr. Blandino, and anything that is going to change in his life is that prison and the fear of future prison is something that generally deters, and specifically deters, his bad and criminal behavior. I think that is probably the most clear theory of punishment that needs to be met in this case. What also becomes clear is that the fear of being incarcerated is something that is real to Mr. Blandino. It's something that does affect his behavior. As we've seen every single time he was looking at potentially being remanded from house arrest, what did he do? He filed frivolous motion to disqualify after motion to disqualify, trying to interrupt these proceedings inappropriately so. What did he do? Right before this sentencing hearing, where he knew the state of Nevada is going to be coming in here and asking for him to be incarcerated, he files another frivolous motion to disqualify. This is something that I think we take into account here as we go forward and we craft a sentence for Mr. Blandino. And what I'm asking for is a sentence that will do just that. Number one, we have 134 days credit for time served. What I'm asking for is first, as to count two, the maximum punishment of 364 days in the Clark County Detention Center. And then as to count one, I'm asking for a consecutive sentence of 1 year minimum to 10 years maximum. The effect of this sentence will be that the defendant will essentially serve maybe 18 months, maybe 12 months before he comes before the parole board. At that point in time, it's going to be incumbent upon the defendant, his counsel at the time, anybody who's coming to speak for him, whether he has other fans that are coming in at that time, to show the parole board that he is somebody that should be released in the community. But the number one thing that this punishment does is it gives him the maximum amount of punishment on the back end of his sentence. 10 years of punishment hanging over his head. Something that will give him a longer term of supervision than probation ever could. Something that will give him more worry about going to prison and more concern about having to correct his behavior in the future and ensure that he's not introducing himself in a criminal manner into our criminal justice system or into our justice system as a whole during that time period. So that is why I believe that is the most appropriate sentence here in this case for Mr. Blandino. Again, probation is just simply not an option to adequately punish Mr. Blandino. It doesn't serve any of the prominent theories of punishment in this case, that being, number one, deterrence, both specific and general, as well as retribution. And so with that, Your Honor, I'm going to ask you to impose that time. I also would mention that the defendant had previously brought up that he was going to seek to have credit for time served or apply for every day that he's been on house arrest. That's just something that is not supported by the law under NRS 176.055, as well as the case of State v. Jackson from 2005. House arrest is just simply not counted towards credit for time served. I would further mention that the Nevada legislature, shortly after they did change the probation structure, which makes probation inappropriate for the defendant. In this case, they also sought to include house arrest in the credit for time served calculation in AB 160, which did not pass. So with that, Your Honor, I ask you to sentence the defendant as to count two, 364 days, as to count one, a consecutive 12 to 120 months.
Anything further?
No, Your Honor.
Okay, Mr. Blandino, do you want to say anything prior to sentencing?
Oh boy, here we go.
I'm going to get a speak.
Would you like
Yes, I have lots to say, Judge. Can I cover what Mr. Dickerson was doing?
That's your opportunity.
I'm allowed to do that? I've got a lot to say. You know, I think I'm just gonna run through his points because they're so fresh in your mind, and then get to what I was going to say before I heard such lies from Mr. Dickerson, and they were lies. These things were unfounded, he said, and they were based on hearsay. He brings up Narvi Bradshaw. No, my religion is not whatever I want it to be. You know, the Lord is my shepherd, I shall not want. The scriptures are very clear on that. We're supposed to eliminate personal and selfish wants. This quote that he said, why I couldn't become a lawyer, is because if I did the bar and I really tried to represent my clients as much as possible, I'd probably be suspended or disbarred.
That's correct.
Or
Probably would.
I would be
You
because
conducted yourself the same way.
nobody fought zealously and vigorously, and this, then they think was a great standby counsel, but he's afraid of you, he's afraid of the district attorney, and you cannot operate out of fear. And I cannot operate out of fear except fear of God. Now, given the opportunity to move forward, as Mr. Dickerson said, this is not true in that I had valid reasons for filing every motion to disqualify. And it doesn't matter, it's 23. There was multiple motions to disqualify that I had to file before I finally got a judge from another district to hear the case. So you can't calculate those in, because I was successful in getting another judge, albeit just to hear the motion to disqualify Judge Wilson. That's in the record. This isn't fantasy. This isn't some federal court judge that is making things up. And he did make some things up there. The Judge Wilson could have been, Judge Bell easily could have said, no, Judge Wilson, you're going to get this case in chief, rather than just a motion to disqualify. So it took repeated motions to disqualify just to get that. Then you have to start anew. You can't put it as one continuous continuum as though they're all equal. This latest motion to disqualify is on good grounds, and there's good current events happening. You've got your address on somebody else's house sitting up there, and Justice Kavanaugh is threatened to be assassinated. He's a Supreme Court justice because of the impending Roe versus Wade case. The person's living in that house, and you had a death threat against you by a defendant. You testified in a case because some maniacal defendant threatened your life, and you testified. That's a matter of public record. So you are a person that, now in the Judge Salas case, where I put in the motion to disqualify, that's where a U.S. District Court judge, his son, was killed because they got the public records of that judge, and now they're sponsoring federal legislation to eliminate those. But you, when refusing to give these monies collected by the treasurer, you put somebody else's life in jeopardy. And that's callous and careless disregard of somebody else's safety. All you have to do is go down to the treasurer and claim that money, and then the address gets taken off the website. The sending package to the firm, I got a note there. Anyway, more for primary rehabilitation is not an option. By his own his relation of the events, the conviction that happened on the violation of custody rights, there hadn't been any kind of gun incident or anything in all these years, 20 years, and you properly, in the trial, forbid Mr. Dickerson, because you knew it would be more prejudicial than probative, to introduce that old conviction to the jury. But now he knows he can bring it up here and try to inflame your passions as somebody who has been threatened by a defendant. Attempted murder, I believe, conviction was garnered in that case, but I'm not sure of that. But the rehabilitation, I've worn this ankle bracelet now on and off for over 3 years. It's been since May, well, I've been incarcerated May 21, got out on the 29th. So on and off since May 29th. This latest thing that you did graciously, I have to admit to that, gave me bail pending this sentencing. You put me on high level, moved me up to the mid-level. But I have a curfew, and I didn't violate any of that. No, there's been no house arrest review. So for him to say There has been no rehabilitation as he jumps from 1994 in some flux DeLorean capacitor, device and jumps forward as though there hasn't been life that has lived between then and now, and good behavior on my part on the house arrest. You'll remember the ankle bracelet was taken off so that I could go visit my PhD son. Both of those boys are a blessing to me, Zachary and Andrew, both in their own way. Low maintenance kids, no drugs, no smoking, no any of that junk. And I can tell you, which the record will not reflect, and it can't, if I wouldn't have taken those kids or not returned them from a visit, I was given them on a visit by Nancy voluntarily. I didn't bring that back. True enough, I did pre-plan that because of the danger those kids are in. Those kids would have been dead. It was only that life-saving measure. And the other thing he doesn't bring up, which he could find the information, sure. I was offered a plea bargain in that case. I could have taken a misdemeanor plea bargain, credit for time served of 1 day. 1 day I spent on that charge when I was voluntarily brought myself back to the state. And I turned that down because the statute was bad. And I felt I owed it to other individuals that had subsequently been prosecuted. To my knowledge, I'm the only one that ever got a felony on that charge because I took it to trial.
Yes, and he passed.
Because I took it to trial, rather than give me the misdemeanor drop was what the legislature intended. We moved that charge from misdemeanor up to a felony in 1980 so that the FBI would extradite from another state. They said, well, in the interest of justice. And sure enough, that legislation was changed. The statute as it was then is not as it is now. And I pointed that out to him. As a matter of fact, during the time I was in prison, when the legislature modified
If you
it.
want to talk about something that applies to this case, I'd love to hear it.
I did not ever tell the kids their mom was spiritually dead or had spiritual cancer. I told other people that later. Never would tell the kids that. As a matter of fact, they didn't even miss their mother during that time, the 8 months that I had them. Exclusive custody. As a matter of fact, that's the other thing too. I went to a licensed attorney, Bob Luke, that signed that letter, was a practicing attorney before I took exclusive custody of the kids. I asked him directly. He's a licensed attorney, worked with John Pageant. He's a former family court judge now. I asked him, is it a crime if I take exclusive custody? My kids are in great danger. He said, well, as long as there's no court order, that is not a crime. Now, it may be bad legal advice, but I followed it. I wanted to know whether it was a crime or not. And he said that it wasn't. And so this probation, I've already had 3.5 years worth of probation on this ankle bracelet. I've appeared for every court appearance. You have disputes on that?
What do you think is appropriate?
Huh?
What do you think is appropriate?
Well, obviously, new trial. I filed a motion in that regard. Ben did not, he didn't.
What do you think would be an appropriate sentence?
You mean if I had no choice otherwise than new sentence?
What do you think would be an appropriate sentence?
I'm asking you a condition on that, Judge. I don't think any sentence is appropriate. I think
Okay, so
if you,
doesn't want to answer my questions.
Wait a minute.
Go ahead.
How do you want to ask that question again with all the qualifiers?
What do you think is an appropriate sentence?
I don't think I committed a crime, Judge. I was trying to resolve a legal dispute. I took the very discipline that you had and Winker had against you with the Commission on Judicial Discipline, and for those 2 days, I used that as a template to go to Mr. Federico, because he asked me over the phone, and I told him, if I don't get an apology, there's no sense in me preparing a document. I was preparing a pre-filing.
Okay, so anything else regarding the sentencing? Because I've heard all the facts and I've heard all the witnesses.
But here's the thing, Judge.
Oh, no.
You really should have disqualified yourself.
Okay.
Asked for it to be done,
Anything
no
else?
tongue. No, you want to cut me short again, and I have a lot to say here.
Because you keep talking about stuff that we've already resolved, and we're not gonna redo it. We're not gonna rehash.
It was all
So
in the
is there
world.
anything further?
Look,
If not, I'm gonna have Mr. Bickman speak.
look. You should not have been removed in 2015 by the Commission on Judicial
Okay.
Discipline. You what you did to Rita Dotson was so wrong, you knew it was wrong, and then you lied to the Commission on Judicial Discipline.
He doesn't want to speak anymore.
I'm sorry,
So
this
Mr.
is part of
Bateman,
it. No,
sit down.
I have the right to speak under common
You're
law.
done.
I have the right to speak
You're
under
done.
common law, Judge.
You're done, Mr. Bateman. Do you want to say anything?
Yes, please.
Sit down. Okay, can I ask one more thing? If you had to take a
Mr.
sentence,
Blandino, sit
I should
down.
be given no more than probation. Does that answer your question?
Yes.
This woman here, I take care of her. Michael,
I understand. I know
I
that.
need to take care of her.
I know that.
I will do all the public
I've seen her
service I
here
did.
today. I know that.
Yeah, I got the medical studies that Ben's doing. I got a 5-year study that can help a lot of people. I'll donate the money to charity. I do not want the
So
money.
you do have the ability to talk about sentencing when directed to.
Okay.
Okay.
Can I talk about it then?
Bateman,
Can I
go
talk
ahead.
about it then?
Mr. Bateman, now I want
Can
to
I
hear from
elaborate
you.
on that?
I want to hear from Mr. Bateman.
Yes. Thank you, Judge. As for sentencing, you've heard from the state, you've heard from the defendant, and I don't know if we're going to hear from Mr. Federico, he was noticed, but, and I think what's appropriate here, I think to bear in mind is one of the admonishments we gave the jurors is to, I think it's still apropos today, is to sort of separate our personal feelings about Mr. Blandino and sort of the, our ability to see objective reality. I mean, everyone who's been involved in this case has suffered indignities, personal insults from Mr. Blandino being a part of this case. So it's, I think, appropriate to step back and sort of dispassionately look at what we have here. And I think one of the points that Mr. Blandino made that I think is valid here today is that there's a significant passage of time that the issues that the state brought up of his prior case in 1994 is really not relevant to what we have here today. There's been a significant passage of time of him not doing anything, saying that he has no respect for the law. And if that were true, you have a long string of arrests, convictions, and other run-ins with the law. He's been on the electronic monitoring program, Judge, yes, off and on, for 3 years without any incidents. He can submit and obey authority. He can. He's shown that. I think additionally, he hasn't been to Mr. Federico's house. He hasn't been to his office since April 25th, 2019, the last time he dropped off a letter. I know Mr. Federico testified that he body saw him and other things, and I understand. Maybe it affected him, but his subjective beliefs aren't, like I said, we need to look at the objective reality. Mr. Blandino he was on an ankle monitor, never went anywhere near Mr. Federico or his family or anyone or anything, anyone in his family or anything of that in that nature. He hasn't violated the stay away order also from Judge Courtroom. He hasn't gone and done anything of that matter. And in fact, if you recall during the testimony of the trial, detectives went to his house. They searched his house, pursuant to the search warrant, and they didn't find anything that was threatening at all, nothing that would raise a red flag. That's because he's not a physical threat to anyone. He is not. And so I don't think it's appropriate to send someone of his age to prison based on that. He's not really a physical threat. And he's, let's be, and I think anything that the state brought up, I think certainly can be cured with conditions of probation. Because he has, and I think it's right what Mr. Dickerson said, that the threat of going to prison or incarceration motivates him. That's why he didn't violate his house arrest. That's why he was perfectly compliant, because he knows what the consequence of that would be. I think that same similar belief will be in effect if Your Honor should grant him probation. And I think that, okay. And to say that, to say that he has zero respect for the law is not proper. What he cited were examples from more than 2 decades ago, almost 30 years ago. But what's more recent is that he hasn't had any incidents on house arrest, no contact, and I think the things are overblown. The threat, I think we're giving him maybe too much credit. On all the legal filings can be cured really by any condition of probation. Additionally, we have counsel who will be representing him on health matters. And quite frankly, I mean, it's ironic, the Supreme Court denied the one filing he made, citing Blandino v. State, his prior conviction in the twist of irony. So I think if you make a condition of probation that any fugitive documents filed while on his pursuing his appeal would be considered a violation of his probation. He'll have counsel who is very experienced and very capable of handling that. And so any abusive process, quite frankly, can be curtailed, can be cured with conditions of probation. Additionally, as he does care for Ms. Pendergraft, I think that is perhaps one of the redeeming qualities he has that I think helps keep him grounded, keeps him centered, keeps him focused. And I know he does a lot. He does a lot of work on her behalf, and he did that. He knew the family prior to her when she was with her. I believe they were neighbors. Knew her family, knew her husband, and then he passed away. And then her son passed away. He made a promise that he would take care of her. He has, and he's done that, I believe, for the last 13 years or so. Okay. So sorry, fortunately, he didn't know her husband before he passed away. He didn't know her son was, they were neighbors, and made the vow that when her son passed away, that he would take care of her, and he's done that. And I think that's another reason why probation would be appropriate, because again, that fear of incarceration. He knows the effect incarceration would have on Ms. Pendergraft. I don't think he would risk it, quite frankly. I think, not to insult him, I don't think he's a threat or someone who we should see as a threat. I think it's a little bit more someone deserving of pity. Quite frankly, his and all of these filings that he's done, the 2 things he's gotten were letters of caution issued to Judge Baird and Judge Curtin. And you have to understand the Nevada Commission on Judicial Discipline to even understand their process and their machinations to really even understand the letters. And we heard, because no one else had ever given him the time of day. No one on all his previous filings, he's doing this for years, at that time when he was staying out of trouble, no one ignored it, and he went away. There was nothing. We're here because, Mr. Federico did something, and
Mr. Federico did.
pardon? Because Mr. Federico contacted the police and started that ball rolling, is what I mean. And to say that, and the statement that, they contacted Mr. Federico, but Mr. Federico asked for that. When he called him and said, what do you want? What do you propose? Give it to me in writing. Okay? Send him something. Okay, give me something else. So, I don't know that it's entirely genuine for the state to say, he kept harassing Mr. Federico, sending him things that they were being asked for, and sort of laying that trap. Again, these things are, I like to say, it's almost more deserving of pity. The letter to the partner, you want to read it. It was, again, that's what's open. It was woefully unprofessional. I honestly, I don't know that Mr. Federico's job, and I can't say that, but I would speculate just that the partners knew that this was not someone to be taken seriously. I don't believe that his job was seriously in jeopardy. Someone of his reputation and renown here in the legal community with his partners and having this letter, I don't think was something that, again, was taken seriously. I think we're giving too much credit for his ability to cause. I think he is deserving of probation, Judge. I think someone of his age, of his temperament, would be a target in prison, and it's not, it's not appropriate. I mean, I think, look, the law is what the law is. The state legislature passed these new laws as to probation, and we ought to respect the law. That's a thing that came from this trial, and so I think, despite what they are, they are what they are. And I think the fear of incarceration for Mr. Blandino is real. I think that he should be given probation. I don't necessarily disagree with a longer sentence on the back end, so that he would expire on parole, and I guess have a long time to expire on parole, if you want to use that appropriate. But I think you'll see, Judge, that if given probation with the threat of going to prison at his age, I think he'll comply. He'll be compliant. I think the concerns about filing or doing other things, I think that's really the main, threat as well, would be filing things that are not germane. He has been deemed a vexatious litigant, so in that regard, that's cured. As a first, he has to get permission, I'm not exactly sure how it works, permission from the chief judge, I believe, in order to file. And so I think, and then
He really
anything on
didn't
his.
do that with these last filings.
Pardon?
He didn't do that with these.
I understand.
There's about 3 different things that were.
And I understand, and I think that's why I suggested making it a condition of his probation that, I think it's not on his appeal, since he's represented by counsel, that any fugitive documents that are filed would be considered a violation of his probation. I think that can be, would cure that concern. That obviously wasn't, it was discussed at his release. So I think, Judge, he obviously, he doesn't feel that he did anything wrong, I understand that. And, but I think that probation is appropriate while he seeks his appeal. He will be represented by counsel, and so I think it is appropriate to grant probation. I think the long term at the end, so he doesn't, takes a while for him to expire, is appropriate, and I would submit on that.
In accordance with the law of the state of Nevada, this court does now sentence you as follows. In addition to the administrative assessment, the DNA fee, and the collection fee, you'll be required to submit to genetic marker testing. As to count 1, the court's going to sentence you 12 to 120 months. Count 2, 364 days in the Clark County Detention Center, concurrent to count 1. It'll be suspended. You'll be placed on probation not to exceed 3 years with the following special conditions. You'll be subject to intensive supervision pursuant to NRS 1768.440.
Wow.
And be appropriate by parole and probation. You're to have no contact with the victims in this matter, either directly or indirectly. You are not to file any documents unless they're consistent with the vexation litigant order. You're not to file any fugitive documents.
1 to 10 concurrent. Wow.
You're not permitted to file documents on your own. Your attorney is required to file those documents, so you'll be required to follow all court orders, undergo a mental health evaluation, and any counseling as deemed appropriate, and you'll be required to comply with all general conditions of parole and probation. Were there any other conditions that the state was concerned about?
We have concerns. We have concerns in looking at the current conditions, the no contact with the victim, directly or indirectly. Defendant has been already trying to indirectly contact Mr. Federico, as he has filed a pro per civil suit against Mr. Federico in the federal court for this, for going to the police in this case, essentially.
That was filed in July
It's
of this last year.
again something that's totally appropriate, and he's been using Mr. Federico's counsel tried to talk to the relay.
She gave the state's recommendation except concurrent as opposed to consecutive, as far as I can tell. Literally everything that Dickerson asked for.
Into him, some proposed offers, settlements, and whatnot. Again, it's just another action by Mr. Blandino that's totally inappropriate. So, I don't know how the court wants to handle that.
They have no contact with Mr. Federico at all. I mean, obviously, if they're in another litigation, he can have contact with his attorney only. He's not had any contact with Mr. Federico. Anything else?
Further,
Wow.
we would ask that the term be fixed. Because I just think that we're in a position right now where he's going to be up for discharge in 18 months. It's just going to be inadequate for any type of supervision over him. Further, we
I think a fixed term would be appropriate. I can set for a fixed term. I believe they will still submit.
Yes.
And so I'll make that determination at that time.
In addition to that, we would ask for a full financial disclosure of the defendant. I think that what's been called into question as far as his finances is his current living situation. He's relied heavily upon his caretaking of Ms. Pendergraft here in this case throughout to avoid any sort of incarceration or prison sentence. The state does have concerns about that situation overall. He's indicated that he's being paid $500 a month by Ms. Pendergraft for his caretaking services, but obviously that's disclosed there. We just ask for a continued financial disclosure in this case.
Okay. To his probation officer?
Please.
Okay. And that you make full financial disclosures to your probation officer as deemed appropriate.
And then does I just want to make sure whether the general conditions have it or not, but I think it should be specifically stated is a full electronic search clause.
Oh, sure. Yeah, that's
I'm
part
sorry,
of the.
I missed that part. Full
Yeah,
electronic
it's
what?
one of the general conditions of home probation is that you'll be subject to search. Your person, where you live, your electronics.
And further, as with the conditions that have already been placed on Mr. Blandino as far as filing with the courts, we would ask that we continue with the same restrictions, time and place restrictions for Mr. Blandino for the courthouse. This courthouse, as well as the municipal court, that he not be permitted to enter these facilities unless he actually has a case on calendar.
And that's appropriate. Court's going to order that you not have any contact with the courts or go in the courts or the courtroom unless you're there on official business.
I can call him up on the phone though, right?
No, unless you have official business.
No, that's what I'm saying. If I call up to initiate a case.
If you have
or to
official
get documents,
business,
or to get certified documents.
that would be official business.
Okay.
So if you have
Well-
official business that's outside a case your attorney is representing you on.
I got one of
but you
those
wouldn't be able
remands
to do
because
it on
William
this
Williams
case.
said official business,
Okay.
Judge, and.
All right, so he is
within
not,
dispute.
you know what, if I were you, if you have a question, I'd ask your lawyer, because if you come back here on a revocation hearing, it's not gonna be good for you.
And with that same, as far as his official business comments, another concern that's raised throughout his history in this courthouse, as well as within his sentencing memorandum, is that he seems to view and other people view him as having official business in their legal proceedings. We would like that the court make very clear.
It would be illegal, because he's not a lawyer, he cannot represent other people that would be practicing law.
But I can
without
file as an
license.
intervener in the case.
And him seeking any sort of investigation or contacting courts on behalf of anybody else be absolutely prohibited.
That would be correct, because that would not be on his behalf. So at this time, I know you want to appeal it, and the Supreme Court has indicated that you would not be able to represent yourself on appeal. So
The appeal's
this
already
time,
pending, Judge. It's, the
Okay.
briefing's just been suspended.
okay, they're not gonna let you represent yourself,
84433.
okay? Just so you know.
We'll see.
So, good luck, because they're not gonna let you represent yourself. But if they do,
That doesn't mean they
about
won't
it?
let me file a supplemental brief as in
Okay.
Domenico versus
All
State.
right, then that's up to them, and that's why
And
they're
then
the
they say
Supreme
these
Court.
aren't people that
So,
done
Mr.
Sorry,
Bateman,
we are concluded then with the
We are.
sentencing and the conditions, then I would move to withdraw at this time.
okay, so Mr. Bateman can withdraw at this point, and the notice of appeal has been filed, correct?
Yes, 84433 is the case number.
Okay, I just wanted to make sure.
Well, he does have appellate counsel, I believe, will
Reported appellate counsel.
Uh-huh, yeah.
through Mr. Christensen's office, I believe, will be handling all the matters of the appeal.
And so
including the
counsel will
notice.
be appointed now. I would just make sure you check to make sure that notice of appeal has been filed and that it's all good. And then the bond will be exonerated. They'll be released from house arrest. And you're to report to parole and probation within 24 hours of leaving court today.
And just to be clear, new counsel is appointed in this case as well. for all
That's
future
correct.
cases.
And I need to issue an objection to that. I want to represent myself on appeal.
I know, that's what I thought I tried to make clear.
I had to make an
The Supreme
objection.
Court's not gonna let you.
Yeah.
However, if they decide,
We'll see.
then that's
I
great.
just talked to them last month.
That is
And I told them they
fantastic.
can't do that.
I do not believe, if you represent yourself, but if they decide otherwise, that's
They can
fine.
in every other appeal
So
but
that's
criminal.
why I just wanna make sure your appellate rights are protected unless and until they make that decision.
All right, so are you confirming counsel today, Joe?
I am
Thurston?
appointing counsel today.
Okay, over my objection.
Over your objection.
Yes.
Thank you.
And so the motion
All right, we're
to. Go ahead.
All right.
Thank you.
Thank you.
Thanks, Judge.
Thank you.
I hope you're safe. You with me? I said, I hope you're safe at all times.
Grab your things and exit the courtroom before you self-troubles.
Thank you.
Counsel?
It's a normal thing to see. Be safe.
Uh-huh, thank you. Sorry about that.
Let me see, I helped before. Are you gonna give me the?
State versus Richard Babb, C 3563.
Well, there you have it. I apparently got it wrong. I thought she sentenced him to jail, and I'm just reading the chat, and you guys are all saying that that's probation. That must be right. I couldn't hear it very well. She said 1 to 10, and then I thought she put him in jail. She sentenced him on 2 counts. 364 was a misdemeanor. Then she had a felony. She said 1 to 10. I thought she was referring to jail time, not or prison time for the felony. Not that. That's the way I read it. I also like the bailiff on the way out, and he starts up with him, and he's like, "Hey, why don't you just exit the courtroom before you get in more trouble?" I don't. Sorry about that. I just coughed in everyone's ear. I am truly hurting, but that was worth staying for. I don't even know why I'm barely hanging on, but I don't know why he dropped a flex capacitor into his argument. That was crazy. That was crazy. Well, if it's probation, don't worry about it. If it's probation, he will mess it up and end up in jail. I have no doubt about it, because he is not getting the message right now. So I think jail time is what it's going to be. For all the world, I mean, I want to give you some grand, legal analysis. A, I don't really do criminal anymore. I haven't for a long time. And B, what I heard, I thought she just sent him to jail, because she said go to jail for 364 on this and 1 to 10 on the felony concurrent. It sounds like a jail sentence. It doesn't sound like a probation to me. But they didn't remand him. They didn't cuff him on the way out. I thought they were gonna put him in cuffs and take him into custody. A couple other interesting things. He was making the argument that he should get credit for time served in home confinement. Apparently, that's not the law in the state of Nevada. I wouldn't know, but I trust Dickerson on such points. Thank you, Mount Zookeeper. So that. It took us a long time to get there, but I did enjoy watching Kim go. I'm still concerned. Do I have criminal defense people here? I'll have somebody on to explain it. I swear she just put him in jail, but they're not taking him. So apparently she didn't. I don't know what that means. Oh, she said suspended. Okay, thank you. There we go. It's so that she does that and then suspended. Okay. I didn't hear the suspended part. I thought she was just sentencing him to that, which would have been appropriate. And the only difference I saw that was my one comment. I apologize for the volume. I can't control it. It's hard. The volume was awful. It was hard for me to hear, and that's why I just muted most of the time, because I know if my mic's involved with it, it's going to be ugly. So I kind of waited to talk to you guys afterwards. But yeah, that was ugly. I thought Dickerson gave a really nice closing argument. I thought Ben did a really nice job defending him, but it was all undercut by his client. Yeah, this is all suspended, fine, but they got it hanging over his head. So if he just keeps going on like he does, and I think he will, then he'll end up with that time. And if he knocks it off, well, then that's all that anybody ever wanted. So it's interesting. It's interesting. He did spend time in jail for this. He spent time in jail for contempt when he wouldn't get his evaluation completed, and then he complained when he was being let out of jail. That may be my favorite moment of all this. There's lots of fun moments. Oh, also he's appealing something to the Supreme Court. The Supreme Court now contains the member who told him not to be an a-hole in court. I think that's not going to work for him. So we'll see. We'll see how it all goes. Well, thank you all for coming out and hanging out with me for this one. I'm hurting. I mean, it's not like a difficult task. I'm at my place here. I've got this ridiculous ascot on. But other than that, I'm pretty comfortable. But I don't know if you can hear it, but I don't sound good and I don't feel good. It's regular cold. I just need to nap and I'll be fine. So thank you all for showing up. I wish I wish I had some better analysis for you, but I got the sentence wrong myself. I didn't catch the suspended part. So what that means, though, is if he violates the terms of his probation, then they can just reimpose that instantaneously. It's all hanging over his head. So there you go. It's a suspended sentence, and they can impose that on him at any time if he can't behave himself, and we all know he can't behave himself. So maybe I should book him on the channel before he before he gets brought in on a violation, and I won't be able to talk to him anymore. I actually like him. He just doesn't get it with court. He just doesn't get it. Still doesn't get it to this moment. He doesn't get it. He's walking out of that courtroom saying, "Yes, I won." That's what's going through his head right now. I know him. Yeah, I sent I had sent a link to Artie during this, but I think he's at work, so he can't. Same deal as Deborah, a government employee. He can't do those things without getting in trouble, which I totally understand. Holy shnikes! What happened here? I don't want to miss these now. Cerebral tackle. Get better, bud. Thank you. the thruple brawl on the cruise ship. Is there a thruple brawl on a cruise ship? Oh, if there's a thruple brawl on a cruise ship, I need to know about it. I really do. Someone needs to send me the link. I mean, I don't know if that's facetious or if it actually happened, but if it happened, I've got to know. Was that a threat at the end? I didn't catch a threat at the end, but I don't know what you're referring to. I mean, it's would he threaten somebody? Oh, absolutely. I did. You tell me if I succeeded. Somebody somewhere during the stream, someone said, "Hey, slow down the chat." I did do it. I think. I don't know if it happened. Tell me if I was successful. I don't know what the genetic marker testing is about, honestly. That baffled me too, much like the flux capacitor. Genetic marker testing for what? For what purpose? We're here on sentencing on an extortion charge. What does it have to do with genetic? I don't know. I don't know. Maybe someone in the chat can tell us. That came up. That came up in another case, but I can't remember the context where they say they do that all the time now, but I can't remember why. Someone's explaining here. All felons, what? Oh, I told the judge to be safe. Nah. That's a dumb thing to do. You could, yeah, it's borderline. I don't think that's actionable. It's sort of in practice is sort of a modest threat, but nobody really thinks he's going to carry this out. It's more puffery. Chat is in slow mode. I managed to turn slow mode on midstream. That was a bonus for me. All right, thank you all. That is the end of the saga, but there will be more. There will be more, and I'll tell you why. First of all, Kim will get in trouble. Second of all, I'll probably talk to Kim and/or Ben and/or Dickerson. I don't know when, I don't know how, but I just imagine that in the future of Let's Talk with Mike, because the case is too fun. All right, thank you all. I don't know, that turned into a long stream. That's what I said yesterday. I was sort of promoting. I'm like, this could be done in 10 minutes, but it won't be. It won't be. I admit that most of this, once it started, I think it was fairly on point. She let him go longer than most judges would, I think, but not by too much, and it was at least relevant. A big part of the delay here was just blowing off the rest of the call. That was not the Kim Blandino case. All right. Well, thank you all for hanging with me. I'm going to take some cold medicine and pass out. That's my plan right now. I will see you soon.